Officer, let's proceed.
Good morning. All rise. Court is now in session. The state of Michigan 36th District Court is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no eating, sleeping, talking, gum chewing, or arms resting on the bench. All electronic devices must be on silent. Thank you.
All right, this is case number 24-163691. This is Discover Bank versus Andrew Bowers Sr. That's Andrew J. Bowers Sr. The matter is before the court, set on for a status conference. This is the first hearing regarding this matter. All right, your appearance for Discover Bank, please.
Good morning, Your Honor. Andrew Cates, P78292 for Discover Bank.
All right, thank you, Mr. Cates. Good morning to you. Looking for Andrew Bowers Sr. Is that you, sir?
Yes, sir.
All right, good morning to you, Mr. Bowers. All right, so this first hearing addresses the nature of the complaint that is filed and whether or not the parties are in a posture to resolve the matter, or whether the court needs to set the matter up for further proceedings. The claim in this matter is for some $8,448. It is alleged that this relates to a Discover transaction. Just looking through it quickly, and a credit card. All right, so have the parties spoken on any other occasion, Mr. Cates?
Not to my knowledge, Your Honor. This is looks to be a relatively well, we filed back in August of last year, but looks like this is our first time here. So I don't think we've actually had any contact with the defendant other than the defendant filing his answer, which really doesn't seem to dispute the amount or any of the circumstances relating to the issuance of the card.
All right, so my question had to do with whether or not the parties had talked, whether you and the attorney had talked before. It sounds like that had not occurred. The second thing is that I looked at the answer that you filed, and it does not seem to be an answer that really denies that this is your debt. Or what's your position regarding this, Mr. Bowers?
I just asked the court for the lengthiest extension that I can have to repay Discover. I have no dispute on whether I owe them, what I owe them. No dispute at all.
So, Mr. Gates, I'm not sure if you heard Mr. Bowers. He was saying that he's not really disputing the indebtedness. He wants a strategy for trying to get this paid. So, sir, typically what that would mean is that the parties would enter into some type of consent agreement with a payment arrangement. So what were you thinking? What were you thinking as a monthly or bi-weekly payment to pay on this case?
Monthly, I'm stretched kind of thin now. I take care of my dad. He's 92 now. He's been living with me since December of 2019. I believe I received a Discover card somewhere around that time. And when this all occurred, he had a mini stroke. And I have every intention, or had every intention, to pay Discover back. But taking on my dad's responsibilities plus my own pushed me way behind.
So if you entered in, the thing I'm getting at today is if you entered into a consent agreement regarding this, what would you be proposing as a monthly or bi-weekly payment to try and start paying?
$100 monthly, and I'm hoping, I'm not sure how, if it's possible, to cut off the accruing interest, if that's possible, because $100 a month and still adding on the interest, taken forever.
That's, so you got two things, the amount of the judgment, if there was a judgment there, kind of dictates what type of payment you make, and you can anticipate the other thing is that typically there is judgment interest. Counselor, did you hear the, kind of a proposal, that Mr. Bowers has offered here? He says he would enter into a consent. He will want the interest to be capped on this, and he'd like to make a payment at $100 a month. I don't know if you are in a position to enter into such an arrangement, but that's what he proposed.
Unfortunately, Your Honor, that's quite a bit outside of my settlement authority that was granted by Discover at this point. That being said, we are willing to entertain some sort of reasonable payment amount. It's just I don't have the authority to grant that deal right now, so I would urge him to contact Mr. Duquette, who is the attorney overseeing this case, and maybe if Your Honor would be so inclined to grant us maybe 60 days of discovery so we can do some negotiations and maybe have him submit like some financial information aside from what we have, because all we have right now is basically a stack of invoices from Discover. Maybe if he like sent in some, we could request some financial information and get him set up with a reasonable payment plan and interest rate that way.
All right, so they're not willing, at least at this point, to enter into the agreement that you all. So, I mean, you're most of the way there by being willing to enter into the stipulate to the consent. I don't think there's real defense to that. The challenge that you raise is that you want to talk about whether or not they will stop the interest on this, and what's a reasonable payment. So what I'm going to do is I'm going to go ahead and set the case up today in the normal next steps, which is basically to set up a scheduling board. I'm going to note on the file that you are willing to enter into the consent, and then you'll need to reach out. You'll need to reach out to their office to see if you can reach an agreement. If you can't reach an agreement at some point, you can still enter into the consent, and then you can petition the court, file a form with the court asking me to set the payment. So once that judgment is entered, then you can move to that next step. So I suggest that you negotiate over the next, maybe I'll send it over for 60 days with a discovery order that I'll sign. And then over that period of time, you talk to their office to see if you can reach an agreement, if you can come together on the number. If you don't, then you come back to court the next time in front of me. Then you'll tell me whether you want to go ahead with the judgment, and then you want to ask me to determine what amount you can pay. Okay. So ultimately, if the parties can't reach an agreement, then you will petition the court and say, Judge, here is what I make, here's the money I have, these are the expenses. I want to pay this amount, and then let me decide. You understand? So I'm going to have you come back. I'll set the next action date in this matter for the 12th of June, so about 60 days forward. So June 12th at 9:30 will be the next action date. I'm going to send you some paperwork in the mail, give them the same paperwork, and then contact their office and tell them the discussion you had in court, and that be real specific about what you want to do. They may make a counter offer, they may not. And then you decide whether you want to go along with that. If not, you know that ultimately you're not in dispute with the amount. You just give it what happens after that. And you can always enter into the consent and then file a petition from me, and then I'll decide what the payment is. Okay, all right. So you get some paperwork. That paperwork will have to come back on the 12th of June at 9:30.
If we come to an agreement, you must need to come back.
If you come to an agreement, you won't have to come back. Okay, and then you can always come in on Zoom. You don't have to come in person if you don't want to. Or you can come back, whichever way you want to go. All right, all right. All right, I wish you well, sir. All the best to you.
Thank you, Your Honor.
Thank you, Your Honor.
All right, thank you. Good day, counsel.
You as well, sir.
All right, this is case number 24-173-430. This is Credit Acceptance Corporation versus Chanel Floyd. The matter is before the court, set on for a status conference on today's date. I believe that Mr. Rosen is in another courtroom. Is that what we have on this?
Yeah, if he's not there yet, he must have, he said they had a consent order, and a consent judgment.
All right, so let me check with Miss, do I have Chanel Floyd on this Zoom? Ms. Floyd? Oh, yeah, I see her. Okay. All right, I'll come back to that now. All right, the court calls case number 24-168197. This is Bevel Medical Equipment and Supplies versus City of Detroit. The matter is before the court, set on for a pretrial conference. All right, your appearance for the plaintiff in this matter.
Good morning, Your Honor. Christina Abro, P78224, here on behalf of Bevel Medical Equipment.
All right, thank you, Ms. Abro. Good morning to you. For the defendant, City of Detroit, your appearance, counsel.
Good morning, Your Honor. Chelsea Grimaldi on behalf of the City of Detroit, P8558.
Good morning to you, Ms. Grimaldi, as well. All right, so where are things now? Somebody update me, Ms. Ambrose.
Judge, we did exchange mandatory disclosures. I got a offer from the city yesterday, even though it was it's low. I don't know if my client will accept it, but I will take it back to the client and see where they're at.
So what do you think, Ms. Grimaldi? It looks like maybe a little bit more time will help the parties to discern where they are in terms of this case.
Yeah, the bill's pretty low. The issue is that there's no proof of the underlying claimant having ever been a passenger on a City of Detroit bus, let alone injured while a passenger on a City of Detroit bus. However, I think if we get a little more time, we'll be able to get it resolved, given that the bill is quite low.
All right, thank you. Thank you for the update, counsel. All right, so I'm going to go ahead and I'll go ahead and set it up for early June. That'll give you a little bit more time to work on this. So I'm looking at 6/3/25 and 9/30. I'm sorry. That will be the 4th. My clerk has advised me that should be the 4th. So 6/4/25 at 9:30 a.m. I'm adjourning the pretrial, finding good cause for the same, and then I'll review the matter on that day.
Sounds good, Your Honor.
Thank you, Your Honor.
All right, good day to both sides. See you at that time.
Thank you.
you.
Have a great day.
Right. So Ms. Floyd, good morning to you.
Good morning, Your Honor.
All right. So I know that you're here on the case of credit acceptance versus Floyd. And my understanding is that you talked about this matter with Mr. Rosen and that the two of you reached an agreement. Is that what happened?
Yes, Your Honor.
So I'm trying to wait for him, but I see that this was a claim that involved some $13,738.05, and that there were certain court costs and attorney fees as well. Was there a consent for a judgment to enter for those amounts?
I'm not for sure.
Okay. All right. So I'm going to hold off and I'll come back to you. We're gonna try to get Mr. Russo in here as quickly as we can, so we can go ahead and deal with your matter, okay?
Okay, Your Honor.
So just sit tight. You're right with you guys on the other matter. Now, Clerk, what date did I give on the Discovery Bank?
The 12th. 6:12.
We are on the record in Credit Acceptance Corporation versus Chanel Floyd. The suffix is 3430. Today is the date and time set for a status conference regarding this matter. Your appearance for the plaintiff in this matter, counsel.
Thank you, Judge. May it please the court, I am attorney Richard Rusin, my bond number 35222.
Thank you, Mr. Wilson. And Ms. Floyd did indicate her presence earlier in this matter. She indicated to the court that the parties apparently had entered into an agreement. Mr. Wilson, you may proceed at this time, sir.
Thank you, Judge. I'll be brief. I can tell you that while the case was in recess with the parties being in the breakout room, the parties have agreed to enter into a consent judgment. The consent judgment will be in the amount of the complaint, which was $13,738.05. That's 13738.05. I explained to Ms. Boyd that it cost $160 to file the lawsuit and have the summons issued, and then it cost the plaintiff $64.60 to have that summons served upon her. To bring us up to the present moment, the total taxable cost, as I explained to Ms. Floyd, was $224.60. I explained to Ms. Floyd that the state of Michigan grants me, as the attorney for Credit Acceptance Corporation, a $75 statutory attorney fee concurrent with the entry of these sort of orders, such as we have on the record today. The total consent judgment, Your Honor, will be in the amount of $14,037.65. That's 14037.65. The parties have also agreed that concurrent with the entry of the consent judgment, that there will be a $200 monthly installment payment order beginning May 8th, 2025. I explained to Ms. Floyd how that can be paid to my office. And as I explained to Ms. Floyd, while the case is in recess in the breakout room, as I do now, I now ask for Ms. Floyd's permission on the record to sign her name to the proposed consent order so that I can file that consent judgment with the clerk of the court tomorrow, Your Honor. And with that, I rest.
All right, Ms. Floyd, you've heard the terms as set forth on the record. Are those the terms that you agreed to, ma'am?
Yes, Your Honor.
All right, and I have documented the terms that have been set forth, and I will sign the consent upon its presentment to the court, ma'am, as long as it complies with these terms. So I'll be signing exactly what the parties have agreed to. And my understanding is that it's okay with you that Mr. Rusin submit that with your name on it, given that the consent is on the record. Is that okay with you, ma'am?
Yes, Your Honor.
All right, well, thank you very much, ma'am. And again, I have the documented numbers, and I will only sign a judgment that comports with what the parties agreed to. I wish you well, ma'am.
Thank
Mr.
you.
Rusin.
Thank you, one and all.
All right, this is case number 24-154217. This is Hassan Al-Hassan versus Jama Naik, NYANG. The matter is before the court set for review. The parties previously were in front of me a couple of times, and they reached consensus regarding repair to a property and regarding certain payments. And it looks like something has not worked out as well as they anticipated. All right, your name for the record, sir.
Son.
Thank you, Mr. Al-Hassan. And ma'am, your son can come up with you as well. I know that he comes, I know that he's been here before. You want to come on up? All right, and your name is Jama Naik?
Yeah.
All right, thank you, and good day to you, ma'am. Remind me your name again?
Babakar.
Yes.
Babakar, sorry. Babakar. Babakar.
First name?
Babakar.
Abukar?
Yeah.
All right, got you. Okay, so what's going on here, sir? What's the situation? Update me a little bit.
Yes, on our meeting here, like we agreed on, like they pay me 1,500 and they pay me, like they fixed the back of the house, but they only paid me 1,400, but they didn't fix the house.
So $100 short and then the repair of the house is what you're saying. So what's going on? You can speak, ma'am, or you can have your son talk, somebody talking.
Yeah, I can talk. I'm sorry for that day. I don't come, but I guess. I'm gonna fix. That time is very cold. I call him, I say, you don't find someone? He tell me no. Me, I'm keeping find somewhere. Everyone I start, I'm fine to go look at spending now this cold. You have to wait. The cold come down. Now I'm gonna call that people. They come check I'm gonna pay them. I owe him only 100. I'm gonna pay.
So you're saying that because of the cold weather, that's why
Yeah.
the
That's
previous,
it, yeah.
you say you have some people that's gonna repair it?
Yeah, try to tell me the score.
When did they say they're gonna do the repairs? How soon are they gonna come there and do repairs?
Last month, if you tell me this month they tell me I'm gonna call them back. If you have that damn money, they come fix. Now they're waiting for me.
Waiting for you?
Yeah. I'm gonna put aside the money. I don't work.
I didn't understand the last part. You said you're gonna,
I don't work. Now I'm gonna prepare the money. Every money I have, I put in some place. Now that I call them, they come, they go check, they tell me how much. If you have that money, I give them, I say fix it. Yeah. They're waiting for me. I'll call him only 100. I'm gonna pay.
what do you understand about this, sir? What do you understand about this? There's someone that's coming out to fix it?
Yeah, like as soon as like gets warmer outside, a little warmer outside. The problem was it was just too cold for them to like fix it up because it's like outside or stuff.
Mr. Alessandro, heard anything about this or?
I heard about like that is not true because the construction company, they work building houses, not only to fix the house. They build whole houses during the season. I can give you 1,000 pictures for different companies. They fixing houses, fixing buildings, and they didn't have the excuse of the cold weather. Kind of like having the cold weather as the previous excuse that we had last time. They said like I wouldn't come up with agreement till I showed them the proof that they came up with a different excuse, which is the weather now. But they don't want to do it because the accident happened in 2011, November 23, and now like 25, you get like winter, summer, and they didn't fix it, just like the accident time.
All right. So, if someone is repairing this property, sir, how long is it gonna take to repair? So if a company came out there to repair what needs to be repaired, how long do you think it take to make the job?
I believe like less than a week, they will, the company will come to do that. Like, I don't think like the weather, because we got sunny days last month.
Yeah, I hear you there. Let's get past the weather thing. But in terms of the work, you estimate that if someone concentrated on it, it would take about 7 days or so.
Less than 7 days actually to get that fixed. Less than a week. Yeah.
How long do you think it'd take for somebody to come out there and repair it? How much time do you think it'd take?
It should be about less than 3 days. It should be about less than 3 days. And also, then my mom asked you like to.
Talk to me.
Sorry. My mom asked him to like, if you know anybody that can actually fix it, since you say any construction can actually come and work in the wintertime, why can't you find a construction to come fix it and we don't pay?
So you're willing to pay for somebody that he picks?
Since you said that.
I asked him, I called him. I said, you don't find no one to come fix me this? She tell me, I don't see no one yet.
But if he finds someone to fix it, then you gotta pay whatever they charge, you know?
Yeah, if I have that money, they charge me, I'm gonna pay.
Now we come up to another story, like they don't have the money. So their concern is the time, not like they're concerned the money. So I don't know what they want to say. The time is that issue. Now like we can find out solution, but they said like they don't have the money. That's another issue we're gonna face down the road.
Everybody agrees that this is somewhere between a 3 and 7 day job when somebody gets started with this. So, it's gotta be repaired, based upon the things that have already been talked about here. So what I'm gonna do is I'm going to order that the repair be completed by the 29th of of April. It's not repaired by the end, you got,
But it's supposed to be like, because we waiting all the time since January, so this how to get fixed.
okay, well, let's go back to January. You see the problem there? If you, here's what I think that your remedy is on this situation. If they're not repairing it, you repair it, then you come here and tell me what the cost could be repairing it was. That's, I mean, that's one way to repair. There's no disagreement regarding whether it's got to be repaired. If they're not gonna repair it, then you gotta repair it, and then come to me with what it costs you to repair it, and then they gotta pay you that.
Yeah, what I don't understand is that we already repaired it, right? But then he didn't like it the way we repaired it.
Well, but
So now,
the agreement is, the agreement is different from there. There was a disagreement about that, and the parties stipulated the last time that you were here that there was corrections that were needed, that there were repairs that were needed. Both sides agreed to that. So now you gotta finish that, and whatever that is. And if you don't finish it, he can go and finish it, and then send you the bill or come to court, and I will enter an order for him to get reimbursed for what it costs him to do that. I mean, that's where this case is right now. So you have until, I'm giving you, I give you, 3 weeks from now, you have until the 29th of April to do it. You get somebody to do it, they repair it, it's fine.
We'll
If you
take care of
don't, if you don't, you get somebody to repair it, and the next time you come in front of me, you'll have a receipt.
Because the previous time, like, you were asked to give the estimate, and even that, we didn't bring you the estimate.
Well, and
Kind of like every time they failed to, give what we asked them to have. Like last time, it's our last meeting here today is to think that can be finished, or we go farther ahead to that sort of things. Like, kind of like having them to have 2 weeks more, I don't, that's to their side, nothing but side. Like,
yeah, so
because this today like should be like the final day where we can make the decision where we stop here, or like, I don't know, like to give them more time on their side, not on my side.
I'm not interested in giving anybody any more time. I told the parties when you were here the last time, I gave you a way forward, and the parties disagreed, and you decided to do it this way. That's what you decided. The parties said that we're gonna work together to get this taken care of. And now you have a breakdown in that. That's what the parties told me. I told you something differently. You told me that this is the approach that you were gonna take. So now, what I'm giving to both of you is an end game. Yeah, I'll allow you to give it. Again, you know, if we want to go back, we're not going to get anywhere going back. So the point is here that either they do what they said they're going to do with a date on it now, they do that by the 29th. I said it for you guys to come today for review to see where everything was. I'm not setting it for review now. The point is that the defendants will repair the property by the 29th. They can hire somebody, whatever, by the 29th. If they haven't done it by the 29th, then you hire whoever you want to. Whatever it costs, that's what they gotta pay you.
I have 2 questions.
Yeah, go ahead.
First question, like if they didn't fix that by 29, and if I hire someone and they pay, when they gonna pay me the money back? It's the first question.
That's where you come and get it. That's where you come and get a judge.
Yeah, because that question, like I have, because I'm afraid like this, when they come after the 29 and they pay that contractor, they say like, oh, we need to 1 year to get that payment done. So like, I don't know that.
What you would get is you would get a judge for the amount that's owed to you. And then you have the right under Michigan law to enforce your judgment. Maybe they pay it the same day. Maybe you have to wait the 21 days and then try to enforce it. Maybe you garnish bank accounts. You understand what I'm saying? You don't get, in other words, you don't get anything different than what you would have gotten at the very beginning. If you get a judgment, then you have to go and try to collect that money. You can put a lien on their house, all kinds of stuff like that. But you still have to go through a process. We don't have anything where you could, I'm exaggerating, but where you go with your gun and collect your money, or where the judge come out with the hammer and collect the money. We don't have anything to do with that. And the only way oftentimes that people get a resolution that is favorable to them without something protracted is when they reach some kind of agreement. That's why I initially brought the parties together. They was trying to reach an agreement because that keeps you ideally from a situation where you got to go get it repaired, get a judgment, and then spend whatever amount of time collecting it. Maybe it goes well. Maybe it doesn't go well. I have judgments where you guys have been in my courtroom enough to probably hear some of them, where you have people that got a judgment against someone and they've been trying to collect for the last 10 years. So I don't want that to happen between the two of you. That can't happen. That's why we talk about, we take time to try to talk about a way to agree where both parties say, I'll do this and I'll do this. Because if you got an agreement, then ideally you have a time frame in which stuff can get done and everybody goes away and it's done. If you don't have an agreement, then you got to follow the normal court process. Normal court process, you get a judgment, you try to find ways to collect on the judgment. Maybe you garnish somebody's wages, maybe you put a lien on their house, maybe you put a lien on their bank account, all this kind of stuff comes involved. And that's allowed by law. But of course, everybody knows that that's work and can cause more bitterness and frustration, especially when people live close to each other. The only reason I called you all out, I have tons of cases that come here, others that come to court. The reason I called you all out because you said we're neighbors. You know, when your neighbors, it's a bad situation, but you want to resolve it as quickly as you can because you don't want to be dealing with this for years and years and years and years and years and garnishing wages of your neighbor next door and all of this. But if you have to go that route, that's the route you have to go.
I treated it as a neighborhood thing, but like that goes for 2 years for this issue. If I didn't treat it as a neighborhood issue, it wouldn't take all that time. Because first I supposed to get the garage fixed, and now I lost the garage with that thing that got forced.
Maybe so. Yeah, but even if you had gone through the various legal processes, you still end up with the issue that you raised. When are you able to collect on it? You still end up with that. But again, whether you think about it from a neighbor standpoint, well, I think in this case you kind of have to think about that some, because you're trying to find a way to work through it. But at the end of the day, now the parties have come to a place of consent where there's an agreement that the defendant is responsible for making the repairs. And if the defendant has not made those repairs, I expected them to be done now. I just said it for review because that's what the parties agreed to. So I said, let me take a review of it and see where you are. It looks like the progress has not been made. So what's the next step? The next step is to say, it's got to be done by this day, or you get it done and bring the bill. That means that now you get a judgment and you go from there. Or get the bill, submit it to them, give them an opportunity to pay. If they don't pay, you bring it to court, and then I enter a judgment for it. Maybe you don't get to this part where you have a judgment. Maybe they pay the bill. If they don't pay it, at least your property is repaired now. And what you're trying to do then is get reimbursement for what you had to spend in your property.
So can you ask them when they want to fix it? If not, they can find it. So like by 29th week, I can publish the bills.
Yeah, well,
Ask them what the time they need for that.
We're gonna fix it before the 29th.
if they don't fix it before the 29th, they don't have the right to fix it. Okay? They have until the 29th to fix the problem. They don't fix it, you tell them, don't come over here, I don't want you to do anything. Because now you get the right to fix it and build it. I can't think of any better way that I can bring it together because they're responsible. And they haven't done it to now. They got to do it by the 29th. If they don't do it by the 29th, then they can't do it. You have to do it, and whatever it costs, they have to bear the cost. Right? That's going to be my order. Now, what's going to happen is that, so they have until the 29th to make a repair. I guess what you want to do is get some type of estimates or something. So I'll have the parties come back in front of me on May the 6th. It's not done on the 29th. Well, you want to come on the 29th? And you're smiling and snickering, and that makes me think that
Well, because it's
Let me
just like,
stop you. Let me stop you.
Sorry.
That makes me think that a person who's intelligent is not really thinking too well. Because tell me another way to do this.
no, because they said like they need 3 days to get that fixed. I said, well, less than a week, so
Okay.
to next month, was 30 days.
If it's to their best interest, they want to get that done as soon as possible. If not, they don't have it done by the 29th, then you take it from there. Whatever it costs you to get it done, that's what you're going to bill them for. That's what's going to happen here. Now, the reason I'm giving 3 weeks to do this, because 3 weeks takes away any excuses regarding weather changes. It rained today, it snowed, a blizzard came, you got 3 weeks. If a blizzard comes, maybe it come in week 1, and maybe a storm come in week 2. You got 21 days to get this done. You get it done, good. If you don't get it done, then sir, you're gonna have to get it done, but you know who's gonna pay for it. Now, the only thing I would say next is, Data, you can come and see me on the 29th. I don't care. I just want to see this get done. And they're either going to do it or you're going to do it. And if you do it, they got to pay for it. Now, if I don't care how you do it, you could get together when you leave here and decide that he could come up with somebody to get it done and get it done by the 29th. You can decide between yourselves how you want to do that. Or you can leave it all on their hands.
I'm gonna do what prefer to all of you want. I don't want to do it between them.
What did you say? I didn't understand you.
I said like I wanna come up with agreement where everyone here witness what they are saying. I don't want to do it in the hallway as we did last time. So yeah, like they can say whatever they want to say. Like they want to bring their contractor, they can bring it. They want to fix it their own, they fix it. The most important thing, they fix it the right way. That's the only thing that.
And if you want to, well, you figure that out and you bring, the next time that you all come to see, that's what you want to bring. Either that is repaired correctly, or that you have gone ahead to get it repaired.
I also have another question too. I want to add on top of that. You said that because the first time we fixed the door, you said it's not done the right way. So I just want to know, like, what do you mean about like getting it done the right way? Because
I think what you have to do is you got to speak with someone who has the training and the skill to do that. That can sign an affidavit saying that they've done it to workmanship specification. That they follow the protocols of professional workmanship in that particular area. And that is done to those specifications. And that will certainly satisfy the court if you have someone who has the license, training, and background to do it, and they did the work, and they provide an affidavit that they did it to specifications, then that should be enough. All right. So let me see you back here on. Well, we can set it on the 29th. Come back on the 29th.
You gotta get it.
I got a lot of
Two trials, and you have 2 trials, another trial the next day. We do it on the 1st or the 2nd.
Okay, well, let's do it on the 1st. 1st of May. Law day.
Judge, can I have the spelling of the son's name, please? I need to spell.
I got you. So May the 1st, and I'm gonna set that at 10 o'clock. May the 1st at 10 o'clock. All right.
Judge, can I have the spelling of the son's name?
You either get a judgment for the amount that's owed, or
B-U-C-A-R-R.
need the work done.
Hold on, sir. Wait a minute. Start over, please.
B-A-B-U-C-A-R-R.
C-A-R-R. That's your first name?
Yeah.
Okay. What's your last name?
F-Y-E.
Porter, you just chimed on in while I was still talking. You know you don't do it like that. Ma'am?
That's not what happened.
All right, go ahead and spell your last name.
F-Y-E.
Got it, Madam Clerk, Madam Reporter?
Yes, I have it. Thanks. All
All right, so I'll see you all on the 1st of May at 10 o'clock.
Okay,
No problem.
Thank you.
thank you.
All right.